I'm Joel Chandler. Welcome to another episode of Unsealed. In this limited podcast series, I take you behind the scenes for an unfiltered look at various open government projects that I've worked on in the past, projects that I'm currently working on, or projects that are still in the planning stage. We also discuss various issues that intersect with open government in Florida. Before we begin, I'm not an attorney. I am not qualified, nor am I authorized to give members of the public legal advice, so I don't. What I'm sharing in this episode is based on my own experiences working on open government issues here in Florida since 2008. Today we're talking about how to avoid public records litigation. Avoiding a lawsuit usually has a lot less to do with technical compliance and a lot more to do with one thing: attitude. If there's one theme that runs through this entire episode, it's that the way you treat people matters, especially when they're already frustrated. Most people who make a public records request aren't doing it for fun. They've already got a bee in their bonnet about something. Maybe they think something's gone wrong. Maybe they feel they've been ignored, or maybe they just want answers to something that's been bugging them. The worst thing you can do is confirm their suspicions or exacerbate their frustrations by treating them with irritation or disrespect. There is no benefit to leaving someone with the feeling that the agency has something to hide. So here are some practical steps that agencies can take right now to avoid turning a records request into a lawsuit. These aren't ranked in order of importance because they're all important. And remember, we're starting and ending with attitude because that's where most of the trouble begins. Number one is to make it easy for people to find your custodian of public records. Section 1. 1912 of the Florida statutes says that before someone can file a public records lawsuit, they have to give the agency's custodian of public records 5 business days written notice of their public records request, not notice of their intent to file a lawsuit. But here's the catch. That requirement goes away if the agency hasn't prominently posted the custodian's contact information in its main office and on its website. So if you want that 5-day window to fix a problem before it turns into a lawsuit, you need to post that information prominently. On your website, that means on the home page with no extra clicks. On a smartphone, it should be visible without scrolling through a maze of links. In your offices, it means in the lobby or any other public-facing area. Don't make people go on a scavenger hunt to find it, and post real contact info, name, phone number, email address, and physical address. Because I make so many public records requests, I routinely check agency websites for the custodial contact information so I can be sure to direct my request to the right person. So what I'm about to say isn't a guess. The vast majority of agencies in Florida do not post the custodian contact information on their websites, and I just don't get that. Why make it harder for the public to access records and, at the same time, waive a major defense? Number 2, make sure those contact points actually work. If you post an email address, someone needs to check it regularly. If you post a phone number, the voicemail should be monitored. If you post a fax number, someone needs to see what comes in. Use a dedicated email address for public records requests and turn off the spam filter. Someone needs to review every message that comes in. Number 3, acknowledge requests promptly. Even if you can't produce the record immediately, just confirming you got the request can go a long way. Silence breeds suspicion. A quick, "We've received your request and are working on it" costs nothing and buys you goodwill, and it's the law. Number 4, skip the automated submission portals. I know they look efficient, but they create more frustration than they solve. Many of them don't work well on mobile devices, and they create a barrier between the requester and the custodian. Instead, post a good email address, a working phone number, a fax number if you use one, and a physical address where the custodian can be reached. If you use a P.O. box, you still have to provide the physical location for in-person requests. Number 5, have a conversation. The law doesn't require you to answer questions. It only requires you to provide access to records, but sometimes just talking with the requester can save everyone time. You might help them narrow the scope, point them toward a different agency that has what they're looking for, or help them understand what's available. Every one of those outcomes saves your agency work and avoids frustration. Number 6, don't weaponize fees. Yes, the law allows you to charge for photocopies, certified copies, or a special service charge for unusually large or time-consuming requests. But just because you can doesn't mean you should. Charging unnecessary fees may save you a few dollars in the short term, but it can cost you much more in the long run if it turns into litigation. Instead, talk to the requester. See if you can narrow the request or provide the record in a less costly way. And whatever you do, never use fees as a way to discourage access. That's a fast track to court. On this point, I'm not imagining that agencies sometimes use fees to frustrate access to public records. Repeatedly, I have obtained copies of agency and interagency communications between public officials discussing doing exactly that. Charge excessive fees, and the requester will just go away. That isn't just terrible customer service, it's a crime. But most of all, it undermines public confidence in your agency. Number 7, have a written public records policy and make sure it's worth more than the paper it's printed on. That means having it reviewed by a competent attorney who understands Florida's open government laws and actually believes in the public's right to know. Apply the policy consistently and fairly. Number 8, don't create artificial barriers. No forms, no demands for ID, no requests for the requester's reason or justification. The law only requires that the request be specific enough to identify the record and that any applicable statutory fees are paid. Adding hoops to jump through doesn't just frustrate people, it increases your legal risk. Number 9, consider mediation. The Florida Attorney General's Office offers a voluntary, non-binding, and cost-free mediation program for public records disputes. I routinely offer to participate in this program. Almost no agencies take me up on it, and I think that's a missed opportunity. Even if it doesn't resolve the issue, it shows you made a good faith effort to avoid court. Number 10, understand the role of the custodian of public records. In Florida, the custodian of public records isn't just the person whose name is on the sign. They're the one responsible for making sure the agency's records are protected, well-maintained, and available for public inspection without unnecessary hurdles. Their job isn't just filing paperwork, it's making sure nothing happens to those records and that there are no physical barriers to the public's access. And finally, we're back to where we started. Attitude is everything. If you approach every public records request with the mindset of what can I do to help this person get the records they want, you dramatically reduce the chances of ending up in litigation. You don't have to agree with their motives, and you don't have to like the request, but you do have to respect the law and the fact that these records belong to the public, not the agency. Nothing you've heard here is legal advice, just my thoughts as a layperson who's made lots of public records requests. If you'd like more information about open government law in Florida, be sure to download a free electronic copy of the Florida Attorney General's Government in the Sunshine Manual. If you or your group would like to schedule a free discussion on open government in Florida, feel free to reach out. If you're a public official in Florida and you'd like to brainstorm about how to deliver a better open government customer service experience, I'd love to help at no cost to you, your agency, or the taxpayers. You can reach me at help@criticalInsights.online. I'm Joel Chandler. Thank you for listening to another episode of Unsealed. Remember, the truth dies in the dark.